First of all, can I thank Alman Wally for his welcome to country. I've been at several events where he's presented them, and they're always very well done, entertaining, and he always has a message for us, and tonight was no different. I'd like to thank Tegan Harrington for her introduction, and I'd like to thank the distinguished guests. First of all, Peter Quinlan, soon to be Chief Justice, otherwise known as my new boss. I very much look forward to him being Chief Justice. Justice Jennifer Smith, thank you very much for attending. I note that Judge John Pryor has been mentioned. Thank you for attending. Dr. Adam Thomason, who's the Director General of the Department of Justice, and my partner, Judge Christopher Kendall. So, I was born in 1957, which is relevant insofar as when you look at the world for a gay man in 1957, it was vastly different. The topic which I've been asked to address tonight is the changing experience of LGBTQI people with respect to their political and legal rights in Australia. I was appointed as Judge of the District Court of Western Australia on 8 August 2011, some 7 years ago today. Now, I wasn't the first gay or lesbian judge appointed to a court in Western Australia. However, I was the first openly gay judge to be appointed to a West Australian court, and I was the first gay judge to openly acknowledge and thank my partner for his role in my appointment, my legal career and my life. As I said, since I was born in 1957, a date that would otherwise be irrelevant except for by reference to the changes in the experience of the rights of gay people in Australia, there have been dramatic changes, more so in the field of legal rights, and I'll concentrate on that this evening, and because I'm gay, I'll concentrate on the position of gay men, perhaps, rather than others. As I've said, someone who was gay and in their 60s when I was born in 1957 could only have dreamed of the equality we now enjoy. And the process of fully accepting lesbians and gays as equal legal members of Australia has been the product of significant law reform. And that's had two distinct phases. First of all, decriminalisation, and secondly, equalisation. And in order to fully understand what decriminalisation means, you have to understand some of the history. It should be noted that only gay male sexual activities were criminalised. It's never been entirely clear why that was so, but leaving aside canon or church law, it was early as 1533 that the English Parliament passed the succinctly named Buggery Act, and English law became part of the law of the colonies, including Western Australia, as a result of white settlement. And the laws against homosexual sexual acts were draconian. Typically in England, after initially the penalty having been death, it's hard to imagine now that people were executed for homosexual acts. And in Victoria, the death penalty for certain sexual acts between males was abolished only in 1949 to be replaced by a penalty of up to 20 years hard labour. And I think we need to pause for a moment to understand the gravity of that. You could theoretically be executed in Victoria until 1949, i.e. 8 years before I was born. In Western Australia, the Criminal Code, certainly in 1913, under Section 184, prescribed a penalty for gross indecency, which was the catch-all phrase for sexual conduct between males, of imprisonment with hard labour for 3 years with or without a whipping. And whether or not anyone was actually executed or prosecuted, the existence of those laws had what US courts have described as a chilling effect on male sexual conduct and inevitably on being out. There was no percentage in being out for really hundreds of years. And it wasn't just the laws on the statute book, it was also the attitude of society towards gays. And perhaps a good example of that is provided by the Sunday Times of the 23rd of June 1901. It remains as is now, a pillar of objective reporting. The headline, "Billiards and Bestial Brutes, a seraglio of satires, foul from mantle, sensual stew, den of disgusting depravity." The absolute need of the warning is our justification and our only justification for this article. There are those among our readers who will condemn us for drawing the attention of the police and the public to a revolting and frantic dissipation as near to our doors as Fremantle. And in truth, we do not blame those readers in a certain sense, for we abhor the subject as much as we loathe the brutes who compel us to excrete and expose them. When the abominations of Oscar Wilde and the unutterably disgusting criminal vices of the Cleveland Street Club were published to the world, a shudder of horror seized upon us and made us momentarily wonder if we dwelt on the shores of that sulphurous lake, cursed by the rains of sulphurous fires for the sins of satires of Sodom. And we went on to say, among the visitors to this infamous billiard room, it is credibly alleged, was Mr. W.B. Wilson, who for his loathsome vices is now undergoing a sentence of 2 years' prison in prison on the Hill. I take it that was Fremantle Prison. So it wasn't just a matter of the law, it was very much a matter of society's attitudes. There was a reference to Oscar Wilde, and of course he was sentenced to 2 years with hard labour in Reading Jail for male sexual offences. It destroyed him, and destroyed not only him but his family, and he died in exile in Paris, destitute at 46, someone who had been the toast of London society, English society, for his plays and poetry. And again in 1952, Alan Turing, the great code breaker and computer pioneer, who was probably one of the most important factors in the victory of the Allies in the Second World War, was convicted of gross indecency. He accepted chemical castration in lieu of imprisonment. He died 2 years later in 1954 of cyanide poisoning. An inquest found the cause of death to be suicide. And he was only one of the doubtless thousands of gay men who found it easier to commit suicide and to live in a society which was so much against them, and to live a life that effectively required people to be either outrageously out and completely flamboyant, or to be completely silent. And by the end of 1954, there are over 1,000 men in prison in England and Wales for homosexual acts. And again, I want to emphasise, if you're in your 60s, in the 50s, you would have led a very closeted, very sheltered life. There were these draconian penalties still on the statute book. That's the world into which existed when I was born. But by the 50s, change was being considered, at least in the UK. In 1957, the Wolfenden Report was published. It was a report entitled Homosexual Acts and Prostitution. Again, just the yoking of those two topics together says an enormous amount about how people regarded homosexual acts and how they were to be treated, what was an appropriate topic to be dealt with them. That report recommended that homosexual acts between consenting males in private should no longer be regarded as a criminal offence. It took 10 years for that recommendation to be enacted into law in the UK, despite only one dissenting voice from about 15 or 25 people who formed that committee. Western Australia, it took a further 22 years for homosexual acts between consenting adults to be decriminalised. In 1974, a Royal Commission was appointed to inquire and report upon matters relating to homosexuality in Western Australia. It achieved nothing, and I note I was in Year 12 in 1974. It wasn't, the activities of Royal Commissions really didn't interest me at that time, but it's a measure of how little it achieved that I was completely unaware of it until I started doing some research for this paper. But things did begin to change. There were the Stonewall Riots when, you're probably familiar with those, they tried to close the Stonewall Inn in New York, and the patrons of that inn, led by the drag queens, struck back and overturned police cars, and the violence that had been imposed on them, they struck back. That was to be a defining moment in changing attitudes towards gays and lesbians. And in Sydney, in Australia, on the 24th of June 1978, the protest march that became the Sydney Mardi Gras started. The march was violently broken up by police, and the recent ABC production Riot is a very good history of those events, and the graphic police beatings of protesters shown in that shows the violence against gays and lesbians that the police of that era found acceptable. Little could those police, or indeed the protesters, have imagined that in the early 2000s that the police would participate in Mardi Gras. And that's perhaps a snapshot idea of how much attitudes have changed. In Western Australia, it took 5 attempts to pass the decriminalisation law through the upper house. That Act, 32 of 1989, decriminalised homosexual acts between consenting males. It had a different age of consent for males and females, males 21, females 16. I must say I've never understood why, if it was appropriate to protect, as they would say it, males till they were 21, females weren't entitled to the same protection. They were, to that extent, protected only till they were 16. The Act had 2 other interesting provisions. One was the differing age of consent, and the other was the law against proselytising. And what that provided is Section 23, it shall be contrary to public policy to encourage or promote homosexual behaviour, and the encouragement or promotion of homosexual behaviour shall not be capable of being a public purpose. And Section 24, it shall be unlawful to promote or encourage homosexual behaviour as part of the teaching in any primary or secondary educational institution. But perhaps even more interesting is the preamble to this Act. Typically, Acts have what's called a preamble, which is a bit of an introduction to the Act and what its purpose is. Sometimes it's barely a line, but what the Decriminalisation of Sodomy Act provided was, quote, whereas the Parliament does not believe that sexual acts between consenting adults in private ought to be regulated by the criminal law, and whereas the Parliament disapproves of sexual relations between persons of the same sex, and whereas the Parliament disapproves of the promotion or encouragement of homosexual behaviour, and whereas the Parliament does not, by its actions in removing any criminal penalty for sexual acts in private between persons of the same sex, wish to create a change in community attitudes to homosexual behaviour. And then the law went on. I must say, reading that, I almost see a subtext as we're not gay in the preamble. But I think it says some interesting things. It says that plainly the Parliament, or those who had that preamble put in, believed in the power of the law to affect societal attitudes. Plainly they do. And plainly, when there are severe offences for certain conduct, it has that chilling effect that I mentioned earlier. And it had taken, as I said, 5 attempts to pass the decriminalisation law through the upper house. It passed the lower house easily enough, but there was, at that time, the view of the Conservative parties was that it shouldn't pass through. As usual, those who opposed decriminalisation predicted the end of the world if it was passed, and as usual, it didn't happen. And I note that the present Attorney-General, John Quigley, has introduced legislation to erase convictions of gay men for historical homosexual crimes. That bill is in the upper house, a place that has often not been entirely friendly to gays and lesbians. But the bill is in the upper house, it's been passed by the lower house, and one hopes that before too long, the long and sad tale of criminalisation will be over when the upper house passes the bill. On a much happier note, equality legislation came late in Western Australia, but when it came, it was wide-ranging. In March 2001, the Attorney-General of Western Australia, the then Attorney-General, Jim McGuinty, convened a ministerial committee to assist in the development of legislative amendments to end the discrimination encountered by lesbians and gay men in Western Australia in a wide range of areas. That committee comprised lesbian and gay legal academics, lawyers, community rights activists, politicians, social workers and others familiar with the nature and impact of discrimination, harassment and vilification in the lives of lesbians, gay men and bisexual persons. So decriminalisation was really the first step in achieving equality. It was an important step, and really it had to be the prelude to any of the equality laws going through. But during the time when that battle had been fought and ultimately won, society was changing slowly. Just in medical terms, homosexuality ceased to be seen as a medical condition, and it was just seen as not something that was a psychological disorder. There started to emerge characters in the media, and my personal view is Will and Grace probably did as much as anything to change people's attitudes towards gay and lesbians. We also saw the AIDS epidemic when it became, by reason of the nature of the infection, a matter that was far more to the forefront of people's minds, and the need to obtain medication and encourage research of effectively fighting against the government of President Reagan led to ACT UP and a much more visible gay presence. And that had an effect which permeated right throughout the Western world. So that committee produced a report. My partner, Judge Kendall, was a member of that committee and wrote much of the report. And in its final report to the government, the committee made 47 recommendations identifying those areas which it thought warranted immediate legislative action. That report was tabled in Parliament on the 2nd of August 2001, and the government accepted all but one of the 47 recommendations. And that was ultimately passed as the Act's Amendment, Gay and Lesbian Law Reform Act of 2002. So whereas when When it came to decriminalisation, there had been long periods of delay in passing the legislation, even after reports. By the 2000s, the legislation was passed very, very rapidly in response to that report. I won't mention all the acts which are proposed to be amended, but if you have a look at just the introduction to that report, you will see the multiple acts that required to be amended. And it covered a whole range of areas. Just some examples of the sort of the more prosaic effects on people's lives. If you're a gay couple and transferred a property into joint names, you paid tax as if you were unrelated. If it was a married couple, then only nominal duty would have been payable. So it's $5 instead of $10,000 or $12,000 on a property valued at $300,000. So it was a real difference. The other great difference, of course, was in terms of access of partners to hospital. Prior to that act, although fortunately our hospitals in Western Australia had a policy largely of allowing gay and lesbian partners to be present in hospitals, there was no enforceable right to do that. So the recommendations that were made included such areas as equal opportunity and sexual orientation. Sexual orientation, until this legislation was passed, wasn't covered as one of the grounds you couldn't discriminate on. It covered homosexual vilification, which we call now hate speech, the termination of employment for on the grounds of being gay or lesbian. There were some exemptions to that relating to religious employers. It involved property rights and benefits. As I've mentioned, it changed the tax regime for matters as simple as stamp duty. And it changed the definition of a de facto couple. And in a time before marriage was permitted, same-sex marriage was permitted, the change of a definition of a de facto couple from a man and a woman to include same-sex de facto couples opened access to a whole range of benefits that were previously denied gay and lesbian couples. It dealt with reproductive technology. It dealt with parenting and children. It dealt with human dignity and medical treatment. And it finally equalised the age of consent and ended the anti-proselytisation provisions. These laws have been of tremendous significance to gay and lesbian people in Western Australia. And certainly in this century, support for gay and lesbian rights has been largely bipartisan, despite the inevitable holdouts of people, of minorities, basically small minorities in one or other parties. And I note that while Labor were largely responsible for the legislation in the state sphere that led to decriminalisation and led to equality, it was a coalition government that appointed me as the first out gay man to the District Court and the Supreme Court. More recently, and perhaps the most important act of the past 12 months, 18 months for same-sex couples is the amendment to the Marriage Act. When we were married in Canada in 2003, I never imagined it would be 14 years before our marriage was valid in Australia. And at the beginning of this year, the last hurdle to largely full equality for gays and lesbians fell with the passing of the amendments to the Commonwealth Marriage Act. Although I note that in the way it was done, we were discriminated against even in achieving equality. No other piece of federal legislation other than constitutional change has required what at first was a plebiscite and then a survey before being passed by the Commonwealth Parliament. Originally, the then Prime Minister Tony Abbott sought a plebiscite. I leave it to you to decide why that was so. The plebiscite bill was defeated in the Senate, and the government of Malcolm Turnbull then conducted a survey which was passed by a large majority. The silent majority, so much the supposed bastion of the conservative right, spoke loudly in support of marriage equality. And those who opposed same-sex marriage totally miscalculated, and to compound their lack of judgment, they called for a division when the bill was before the Parliament rather than being passed on the voices. And for those who were watching Parliament live, and I must say it's one of the few occasions I have watched Parliament live, the scenes of great joy in the Parliament were recorded for posterity. At least those four who opposed it had the courage to sit on the nay side of the House. Some of the others were abstained. But it was a great day and a great occasion to watch. So, in my lifetime, we reached a position where we are substantially full legal citizens of this nation. And the last 60 years has seen an enormous cultural shift in the way that gays and lesbians are treated. And this has reflected a worldwide trend in the way gays and lesbians are treated, from the Stonewall Riots to the protest march that would become Mardi Gras, to the US Supreme Court decisions, to the Irish referendum. And it's seen the acceptance of gay and lesbians, and increasingly it has seen an acceptance of people who are transgendered and others within the LGBTQI. But the legal changes have occurred, but we shouldn't kid ourselves that we live in a perfect society. We never will. Because the fact is that homophobia does remain. Misogyny remains. And the fact is that unless let me date myself by referring to the women's liberation movement, hadn't fought against the roles which society assigned them of men being, as it were, on top and women being subservient, unless women had challenged that role, then there never would have been gay and lesbian equality, because the fact is that much of the attitudes towards gays and lesbians emerges from or as a result of a belief of certain positions that people should play in society. And I think it's important that gays in particular acknowledge their debt to women and to feminism. And our task is now not so much political, legal. Our task is to eradicate stereotypes. We need to refuse to tolerate the sniggers. We need to end the unspoken put-downs. We need to end comments such as, "He is so gay." We need to stop accepting them. We need to end the requirement that we need to be twice as good to achieve what straights achieve. We need to refuse to tolerate the sometimes vicious attacks on our suitability, attacks that would never be made on someone who is a straight white male. Politicians, CEOs need to refuse to tolerate people who seek to make such attacks. And we need to be vigilant. Things can change dramatically and they can change quickly. We also need to remember that preserving gay and lesbian rights involves preserving human rights generally. One of the rather unfortunate aspects of groups who are not in power is that the attacks that are turned on them, they tend to turn on others. So we need to be vigilant, not only in preserving, as I said, our rights, but human rights generally. So that's the task that falls before us. The legal battle has been won, but now we need to very much to turn to the other battles. And as part of that battle, we need to treat others as we would have them treat us. We need to be aware of discrimination against everyone because gay and lesbian rights will only have full effect once there is equality and human rights generally are respected. So thank you for listening.